permit, accommodating or harboring an illegal immigrant. The bail applications therefore shall be adjudicated upon in terms of Section 60, subsection 11A of Act 51 of 1977. I direct that the offences fall under Schedule 6 of the Act. I further direct that the bail applications shall be conducted in the Regional Court. Signed at Polokwane on the 9th of September 2024 by Advocate M.I. Tenga, Director of Public Prosecutions, Limpopo Division, Polokwane. That's the conclusion. Your Worship, may the confirmation be received by the court and form part of the record.
Any objections by the defense?
No objection from accused number one.
The confirmation.
Confirm, Your Worship. No objection from accused.
Confirm, Your Worship. No objection.
The confirmation certificate by the Director of Public Prosecutions is then received and accepted into evidence as Exhibit A.
Furthermore, Your Worship, the state consulted with the defense with regard to the place and date where the bail application will be held. And we agreed that the bail application in this matter will be done at Polokwane Regional Court. 120, subsection 1, capital letter A, section 121, read with section 4, and 151 of the Firearms Control Act 60 of 2000, and further read with section 250 of Act 51 of 1977, unlawful possession of ammunition. 5, contravention of sections 5, 9, capital letter 1, and 9, capital letter 3, read with sections 124, subsection 1A, section 32, subsection 2, section 42, subsection 1B, in open brackets 19, Roman figure 19, and Roman figure 8, and section 49, subsection 1A of Immigration Act 13 of 2002, entering or and remaining in the country without valid permit, accommodating or harboring an illegal immigrant. The bail applications therefore shall be adjudicated upon in terms of Section 60, subsection 11A of Act 51 of 1977. I direct that the offences fall under Schedule 6 of the Act. I further direct that the bail applications shall be conducted in the Regional Court. Signed at Polokwane on the 9th of September 2024 by Advocate M.I. Tenga, Director of Public Prosecutions, Limpopo Division, Polokwane. That's the conclusion. Your Worship, may the confirmation be received by the court and form part of the record.
Any objections by the defense?
No objection from accused number one.
The confirmation.
Confirm, Your Worship. No objection from accused.
Confirm, Your Worship. No objection.
The confirmation certificate by the Director of Public Prosecutions is then received and accepted into evidence as Exhibit A.
Furthermore, Your Worship, the state consulted with the defense with regard to the place and date where the bail application will be held. And we agreed that the bail application in this matter will be done at Polokwane Regional Court on the 2nd.
Unfortunately, I cannot stand here and just allow the state to dictate proceedings in terms of a section, supposed section, which finds no application. It would be completely incorrect in law for the state to approach. There's no valid basis for this. So unfortunately, yet again, I believe I'm going to put the court in a position to make a ruling on that. And I would just like to place on the record, it's not I have no intention to ambush the state or my opposing counsel in this matter. But the fact of the matter is, if they responded at all to any of my emails or to any of my inquiries, we would not be in this position, because then I would be in a position where I would have formally filed this, and I would have formally filed and given a chance for the state to prepare on this. But the fact of the matter is, they are completely wrong. As the court pleases.
Advocate Chauke, response.
Your Worship, the appeal which the state intends to launch is not based on Section 65. Reason being that there is no decision which was made by the court with regard to bail application, either in favor or of the accused or against the state. This appeal, which the state intends to launch, is based on the provisions of Section 310 of the Criminal Procedure Act and Rule 67, Sub-Rule 11 and 12 of the Magistrate Court Rules. Section 310 is not that long. I'll quickly read it to the court. It states that appeal from lower court by prosecutor. Subsection 1, when a lower court has in criminal proceedings given a decision in favor of the accused on any question of law, then such prosecutor may require the judicial officer concerned to state a case for the consideration of the provincial or local division having jurisdiction, setting forth the question of law and his decision thereon, and if evidence has been heard, his findings of fact, insofar as they are material to the question of law. Rule 67, Sub-Rule 11 and 12 are more or less the same as Section 307. However, Section 310. However, the rules deals with the procedure which should be followed. And Sub-Rule 11, it states a director of public prosecutions or other prosecutor who contemplates an appeal under Section 310 of the Criminal Procedure Act of 1977 shall within 20 days after the conclusion of the criminal proceedings in writing request the judicial officer to state a case. Then Sub-Rule 12B said the stated case contemplated in paragraph A shall be divided into paragraphs numbered consecutively and shall be arranged in the following order. I'll only read the one which is relevant, which I earlier indicated. On Roman figure 2, it said question of law. Then Sub-Rule 13 states that the director of public prosecution or any other prosecutor may within 15 days after the receipt by him or her of the stated case deliver notice of appeal against the decision or question of law. I disagree that there is no formal steps taken by the prosecution to show that they are appealing. We have taken formal steps. We have requested the court to furnish us with reasons which were provided, and we further wrote back to the court indicating that what we are looking for is a stated case. Therefore, steps has been taken to appeal this matter. Now, according to the rules, the first step to take to appeal is to request for a stated case. Basically, in terms of section 310, the state does not apply for leave to appeal like in other measures. If it was a different section, we're going to apply for a leave to appeal. So the first step here is to apply for a stated case. Once we get that, we prepare the appeal documents and launch it with the Register of the High Court. That's the conclusion.
Anything else, Mr. Advocate Venter?
Yes, the record will reflect that this morning, Section 65 was directly identified as the basis for the appeal. I can accept now that it seems that the state has now changed the flavour of their approach. The fact of the matter is, I would like to challenge the court to specifically consider the matter of S versus Green.
S versus?
Green, where it clearly states that the principle finds application. I've read into the record previously what is the grounds for the statement and the statement to be given to us. Now we are going supposedly to another court, supposedly for an appeal, which I still cannot see and fathom on what basis it's going to be successful, because Section 325 is as clear as it can be. And not only that, it's supported by the Constitution. The Constitution is clear. You can never ever be forced to provide any statement or any information that's to your own detriment. That is the basis of this whole situation. I cannot see why we should go to a high court now, waste the court's time, waste state resources, and also just continue the incarceration of persons that is currently still under the protection of the Constitution. Why is it valid? There's no grounds for this. And we must remember something. The bail application is sui generis. It flows. Anything, it's not something that's specifically bound to procedure. There's several instances that's been recorded where each and every party takes a different route and approach to deal with the matter. But the fact of the matter, you cannot contravene the Criminal Procedure Act as simply as you like, and find somewhere that you can find a piece that you think might validate your argument for appeal. There's no basis for the appeal in relation to the ruling that you made previously, with the greatest respect. And I'll leave it at that this morning.
Adding to that. Your Worship, the state right to appeal was confirmed by the Supreme Court of Appeal in the matter of Augustine Petrus Maria Hoven, who was the appellant, versus the DPP Western Cape, with the full citation being 2022, Volume 1, SACR on 115, in brackets, SCA, on paragraph 43. The court stated that the DPP is entitled under Section 310, subsection 1, to require the magistrate to state a case for the consideration of the appeal court with a view to an appeal on the question of law that has led the magistrate to decide the case in favor of the accused. The process to be followed in preparing the stated case is set out in Rules 67, Sub-Rule 11 and 13 of the Magistrate Court Rules. Your Worship, we have such a right to take this matter to the appeal court. Whether the decision is right or wrong, it's irrelevant at this stage, as the court says.
The matter came before me on the 30th of August 2024, wherein applicant number 1 made an application for access to his own statement in terms of section 335. The application was opposed by the state. The state referred to section 60 sub 14. The court considered both arguments, and the court ruled that in terms of section 335, accused number 1 or applicant number 1 would be entitled to a copy of his statement, and as such the court ordered the state to provide the copy. Immediately thereafter, the state indicated its intention to launch an appeal on the court's ruling. This court had made a ruling already on that date and cannot revisit its ruling. That is something for the appeal court to look at. On the 30th of August, the court informed the parties that it will provide reasons for its judgment by the 2nd of September, which indeed reasons were submitted on the 2nd of September. It's only this morning that I became aware that the state had filed a response or a request from the court this morning that the court provides a stated case. And the court will provide that in due course within the next 2 days. As such, this court cannot revisit its ruling, and it's for the appeal court then to decide, and to decide on your arguments as well, whether it's appealable or not, but that is now for the appeal court to decide. On the 30th of August, no time periods were set for the filing or the launching of an appeal. Those time periods are set in terms of the Act, as Ms. Advocate Chauke had pointed out. As such, the court will then provide its stated case by no later than Friday this week, after which then the state can, if they intend to proceed with the appeal, then they will comply with the time periods as required by law.
As the court pleases.
As the court wishes.
It was then in relation to the 2nd of October and the postponement. Obviously, then we will pitch up on that day. We've got no objections. As the court pleases.
Thank you, Your Worship. Your Worship, indeed we confirm the arguments from my learned colleague, and it has been indeed agreed with by the defence. Your Worship, the 2nd of October is suitable.
I confirm, Your Worship, the 2nd of October is suitable.
Then the matter against you is then postponed to 2 October 2024. The bail application is referred to the regional court to be heard there. The matter will come on the 2nd of October, 8:30 in the morning. You three will remain in custody up until then. So the matter will be heard in Court A, Polokwane Regional Court, 2 October 2024 at 8:30 in the morning.
If you found this video informative, please like, subscribe, and hit the notification bell for more content like this. And as always, let us know your thoughts in the comments below. Until next time, stay informed and stay engaged.